Good evening, everybody, and a very big welcome to the Fifth Estate at the Wheeler Centre. My name is Sally Warhaft. I'm so excited. I'm very excited to introduce you to our guests tonight, and on a subject that clearly there is considerable interest in, despite the endless hours of talk that we hear and things that we read, to have a substantial conversation. Our guests are Dr. John Hewson, former federal member for Wentworth, leader of the Liberal Party opposition for 4 years. He brought his background in economics and financial matters to shadow portfolios, including finance, treasury, industry and commerce. And John now runs his own private investment banking business and is frequently published in newspapers on all sorts of subjects, and a commentator particularly on Sky News. And it's a pleasure to welcome him back. He was a guest on the Fifth Estate in 2013. And Professor Adrienne Stone, who holds a chair at Melbourne Law School for the past decade. She's an ARC Kathleen Fitzpatrick Laureate Fellow, a Redmond Barry Distinguished Professor and Director of the Centre for Comparative Constitutional Studies. She's taught in law schools in Australia, the United States and Canada. She's delivered papers and lectures all over the world and has published widely in journals, including the International Journal of Constitutional Law and the Oxford Journal of Legal Studies. Please give them a warm welcome. I've never started a Fifth Estate with this, but I'm going to get us in the mood by just reading out, it's a paragraph of Alfred Deakin's second reading speech on the Judiciary Bill. He gave it on the 18th of March 1902 when he was Attorney General. And of all the things Deakin did, he said that the establishment of the High Court was his most treasured and cherished measure. So I'm going to talk quite fast too, because that's what he did. What are the three fundamental conditions to any federation authoritatively laid down? The first is the existence of a supreme constitution. The next is a distribution of powers under that constitution. And the third is an authority reposed in a judiciary to interpret that supreme constitution and to decide as to the precise distribution of powers. The Constitution is to be the supreme law, but it is the High Court which is to determine how far and between what boundaries it is supreme. The Federation is constituted by distribution of powers, and it is this court which decides the orbit and boundary of every power. Consequently, when we say that there are three fundamental conditions involved in federation, we really mean that there is one which is more essential than the others: the competent tribunal which is able to protect the Constitution and to oversee its agencies. That body is the High Court. It is properly termed the keystone of the federal arch. It was a magnificent speech. It goes on for pages and pages and pages. So, a little bit just starting with that history, Adrienne, how well did these blokes do in framing the Constitution and setting up the High Court?
So those are two questions, quite hard. They did pretty well for the time. The Constitution now, when we look at it, has some really serious problems with it, not least. In fact, first would be its failure in any way to recognise the First Peoples of Australia would be, I think, what you would refer to its greatest flaw, including, and there is some kind of residual racism evident in the Constitution. But let's put that aside and think about the role of the High Court. In fact, I think the speech that you referred to puts itself on something very, very important, is that if you're going to have a bargain, a compact, that creates the fundamental structures for your society, people are going to disagree about what it means. The states will disagree with each other, individuals will disagree with governments, and you need an adjudicator. So the High Court performs that role, and it has been a resilient, well-performing, and I think highly respected constitutional institution.
How flexible has it been over that time? If just to look at it historically and the challenges that have come up, is it a fairly flexible institution?
So it's an institution that regards itself as governed by the rule of law, that the law provides an external standard by which it needs to judge the correctness of its decisions. So that's its sort of internal, I think, ideology. However, in fact, I think you've seen the High Court respond over time to social and political events. I mean, most notably, it has increasingly centralised power towards the Australian national governments, which I think responded to Australia's growing independence. When we first federated, we really didn't regard ourselves as fully independent from the United Kingdom. As we've become more independent, and as the role of a nation has become more complex, the High Court, I think, undoubtedly has responded by giving the national federal government more power. So it's been that flexible to that extent, yes.
John, in your time in politics, when you think of the High Court and squabbles and challenges and so on, what comes to your mind?
Well, I'd essentially agree with what I've just heard from Adrienne. I mean, I think it's stood us in pretty good stead over the time. I mean, the only point I'd add, I think, is obviously the mixture of those on the High Court has changed from time to time. Sometimes it's appeared to be more conservative than at other times, and I guess in today's issues there's a fair judgment as to just how conservative they might be in the interpretation of Section 44 and so on, which I'm sure we'll come to.
We sure will, yes.
I think I'd generally say I think it stood us in pretty good stead, although social and economic circumstances have moved on a lot. That's naturally seen us with more of a national focus, and they've reflected that, I think, in what they've done. But I think today the pressing issues really are in areas like federation reform and constitutional reform, and they're probably in a very short-term focused, populist, opportunistic political environment, almost impossible to contemplate. But I think that's how I'd assess the process so far.
So one thing to remember, of course, is that the High Court can't itself change the Constitution, and it gets confronted sometimes with problems that no other branch of government has been prepared truly to face. And so it can be a very difficult position for the court to be in. And I think, one of the ways in which the High Court's been impressive is at times it's taken that step that no other institution's been prepared to take. Now, the decision in 1992 in Mabo, I think, was exactly that kind of a decision, that it finally had to face an issue that no other branch of government had faced, and it made a really important decision that then spurred legislative response. So it was almost initiated a kind of dialogue with the elected branches of government that led in the end to, a somewhat more satisfactory resolution of the problem.
Just on Mabo, it's interesting because that was an issue that emerged in my time as leader, and I'm no lawyer, I wasn't sure how the High Court would respond. So I went to the Torres Strait and I went to Eddie Mabo's land, and they're just standing on the dirt road saying, where's Eddie's land? And they could point out, goes from here to the tree to this. There was a land tenure system on the Torres Strait, which wasn't a Queensland land tenure system or a national land tenure system, but I came away absolutely convinced that the court couldn't do anything else but recognise native title, and started to change the attitudes of the party, which that issue was going to be so divisive in the Liberal Party, it wasn't worth thinking about. And but I thought it was very important to have actually gone and done it myself. You can't second judge the High Court, but I mean, I had to get to a view as to whether which way it would go. There've been a number of attempts in the past to actually do something about native title, and they've not been successful.
What you just said, you can't prejudge, you can't make assumptions. Adrienne, before we get to the citizenship saga, Can you just give us a little crash course in how it works? So how many judges are on it? What do you have to do to get on it? And when they're contemplating a case, I mean, they're not sitting around a round table with cups of tea and a bowl of biscuits, are they? They're away in their own offices, their chambers. Tell us.
Okay, and so I should add that my first job out of law school was actually working for a High Court judge. And
Terrific.
So there's things obviously that I can't say, but let me give you a sense of what's involved. So there are 7 judges on the High Court. You get there by being an important combination of absolutely brilliant and very lucky. Appointments are made by the federal government, by the cabinet, usually on the advice of the Attorney General. And the High Court is a general court of appeal, but we'll talk about its constitutional jurisdiction. It does not take all cases that come before it. It chooses the most important ones. It has a procedure that you've got to get past. It only hears about 70 cases a year, and only a portion of them will be constitutional cases. So when the constitutional case comes before the High Court, it's crystallised down into a really important issue. It's argued in the court over a period of days by usually an array of counsel. The states, or if they're not parties, are entitled to intervene in a constitutional case and put their position. And then the court almost always reserves its decision, which means it doesn't tell you the result right then, and they go back and to their chambers and write. Now, practices have changed a little bit over the years. In the United States, it's well known there's a formal voting system amongst the judges, which has never been the practice here. But there has almost always been some process of conferencing, and then of course there's informal consultation amongst the judges. But we have quite a strong tradition of judges writing their own judgments, but they also do join each other's judgments, and sometimes that's one judge joining on to another one already written, and sometimes they really collaborate and write together. And of course the magic number is 4 of 7, and that's the number that we're always, when I was working there as a judge's associate, we're always thinking, which is this judgment going to get 4? It's going to get 4, and then it will, carry the case. So that's the position that you're in.
Mm-hmm. It's good to know that there are more than 7 brilliant potential judges out there, even if they're unlucky. I can almost hear Henry Parkes kind of laughing in his grave about what's going on at the moment, because we had a federal government that was focusing obsessively about a citizenship issue to do with keeping people out of our country. And then all of a sudden, at its heels came this issue of desperately trying to keep its politicians in the chambers, and others, of course. It's affected, numerous parties. John, politicians are setting an incredibly high benchmark for people wanting to acquire Australian citizenship. Don't you think we should have an even higher, or should we have a higher benchmark for politicians wanting to sit in our parliament?
Well, I think so. I mean, I think one of the things that's happened in politics generally is that the standard of assessment of people coming into politics has certainly declined over the years. And you've got a particular focus these days on people who are more or less what we call apparatchiks. They've never had a real job. They come into politics not to make a contribution back into the system, as was the style of the early 1900s, for example, but they've spent their life getting pre-selected. They've worked, they come out of university politics, they work for a minister or a union or local government or something. They manipulate numbers to get themselves pre-selected. They end up, tragically in our system, quite often running very large departments with no particular skill set or experience to do that at all. And in that process, standards have got lost. I think one of the reasons why electorates around the world today are stepping back a bit from politics is that they've lost confidence in government and the processes of government, and indeed perhaps even a range of institutions. In those circumstances, I think in our case, the role of the High Court, to me, becomes even more important, because it's going to sit there as the independent adjudicator of that political process and mess. And as you say, the government was trying to raise the citizenship issue in a very populist way, to stop people coming to this country. or to make it more difficult for them to come to this country. And at the same time, the focus shifted back to whether some of them should actually be there making those decisions. And that's thrown it all back to the High Court, which has got a very difficult task, I might say. We only know of, 11 cases that have gone to the High Court at this stage. We're not sure that they'll actually take all of those. I guess you can answer that better than I can. But there are slight differences in each of those cases, so it's going to be very difficult, I think, a real challenge for the court to adjudicate on Section 44 and whether they should or shouldn't have maintained a standard. It seemed to me that if you're asked a question, are you not an Australian citizen, you should be able to answer that with some authority. And that's the very first question you get asked when you fill in your form. But, it's not easy, I guess, when the rules have just got softened, I think, in many ways about eligibility for politics and the roles that people are expected to play once in politics, and lost some significance to the processes of government. The game has become, the game of politics has become the end in itself, not a means to an end, which is better government and better outcomes for the people of Australia. So, I think there's a very significant challenge right now to the High Court, that you've got that particular issue and others, but that issue. And people are not very good at prejudging the High Court. I mean, I notice a difference of constitutional expert opinion about the postal plebiscite, postal survey, and you've got 7-0 as a determination of the court. And it'd be interesting to see what they are going to do with this dual citizenship issue.
Well, if I had my way, I would just get rid of them all, and I'd say, bad luck. You're the unlucky class of 2017. You're going to be a sad little footnote in our history of the politicians that couldn't fill in a form properly. Get it together and make sure this doesn't happen again. And and there are people in there that I like that are under threat of going, several. Numerous, actually. In fact, really, most of them. But bad luck is what I say, and raise the standards.
A hardline interpretation of Section 44 would have them say, right, you've all signed the form, you're all accountable for what you've done, as far as we're concerned, if you are still a dual citizen, you have misled, and whether it requires another election in the lower house or some sort of sequence, some sort of sequencing in the upper house, it's over to you. And if you don't like the Constitution, amend it.
Well, so allow me to offer another
Yes, and this was
opinion.
my invitation to you, because I'm quite sure you disagree. Yes.
Well, so a couple of things to notice. There is no requirement in the Constitution that you are an Australian citizen.
No.
It's a statutory requirement.
In fact, many of our Prime Ministers haven't been.
I would prefer to see a requirement that you are an Australian citizen rather than a requirement that you not be a dual citizen. So that's the first one way we could improve the Constitution. Now, what are we to think about dual citizenship, this dual citizenship requirement? The first thing as a constitutional lawyer I notice is it's now operating in a way in which the framers could not have intended or foreseen. At the time of the framing of the Constitution, there was no legal concept of Australian citizenship. We were all subjects of the Queen. And we would not have regarded anyone from New Zealand, the United Kingdom, Canada, or any of the other dominions as owing an allegiance to a foreign power in the sense of Section 44. So Section 44 now operates very differently because Australia has now become an independent nation, and we do regard those people as owing an allegiance to a foreign power in a way that we didn't. Secondly, dual citizenship is now much more common than it used to be, and it's often conferred on people without them having necessarily taken active steps to do so. So one possibility is that the High Court might look at Section 44. And I'm not making a prediction here. I'm pointing there's a pathway to this result. There's a pathway to this result in which the High Court takes, I'm not going to predict, but there's a pathway for it to say Section 44 was about making sure that our parliamentarians had their principal allegiance to Australia. And that's the question we're going to ask ourselves. And if there are circumstances in which someone has come into dual citizenship in a way that we can't nonetheless doubt that their principal allegiance is to Australia, then we will recognise that they are eligible to stand. Now, they might, of course, just simply say bad luck. and they could well be entitled to do so given what the Constitution says and what they've said previously. But notice that it will fall very unequally across the political spectrum. It will fall hardest on independents, on new parties, on those people in politics who are not backed by a large party machine with the resources to sort this out. Because if one thing you've learnt through this isn't always easy to tell.
Well, actually, I would argue that it will fall most heavily on the government.
National Party, maybe.
Well, the coalition.
The result of this particular one will, but if a very hard line is taken about dual citizenship, then the burden is on candidates to work out and renounce their citizenship properly, and it's not always easy. And I was very affected by Senator Dastyari saying that it cost him $25,000, a lot of time, and he worried endangered his family in Iran for him to renounce his Iranian citizenship. It's going to be a lot easier to renounce if you have a Kiwi citizenship or if you're Canadian than if you're Iranian. And if we're really committed, one, to being a multicultural society which is properly represented in the parliament, and two, to an open political process where you can figure out whether you're eligible to run, to nominate for parliament without spending a lot of money, where a hardline interpretation of Section 44 places quite considerable pressure on that. So there are some costs in insisting on it.
Didn't the High Court decide in the case in the early 90s, associated with, I guess, the Wills by-election, that you had to demonstrate that you'd taken every reasonable step to...
Sure.
How does that set the scene for what they're doing now?
So that case is called Sykes and Cleary, which we've all been scurrying back to the Commonwealth Law Reports to read avidly again over recent weeks. And if you read it, it does have all these little things in it that I'm sure are going to be seized upon by those arguing the case in the High Court. And one thing the court did say in Sykes and Cleary back in the 1990s was, well, if you have taken reasonable steps to renounce your citizenship, then that will be sufficient. So what we may see, and this is why I say there's a pathway there for the court, is a sort of expanding of that notion. Because it's problematic for those who took no steps because they didn't know they had a citizenship. But there might be a way to take that concept and then to expand it in a way that relates to people who were unaware and maybe reasonably so unaware that they might retain their eligibility. And the High Court could justify that if it were minded to by thinking about what was the original purpose of Section 44. And how was it meant to operate and arguably bringing its operation back to its fundamental sort of function.
While the judges are doing their reading and writing, do they get together to talk about it? Is that part of the natural process?
I think it is. There's no sort of formalised necessary... so practices also may have changed since I was there, and it's not really widely talked about. But certainly in the 1990s, the judges would get together and have what was called a judgments conference, where they would sort of indicate something about their views. And there is also, quite frankly, quite a bit of just walking in and out of chambers and talking to each other. When I worked at the High Court, 4 of the 7 judges used to go on a lunchtime walk when they were sitting around the lake in Canberra, and I have no idea what they talked about, but...
Sounds like Survivor.
It could have been. It could be that sometimes they would talk about the cases. Absolutely. But there's quite a bit, and justifiably, given the importance of that institution, of not exactly secrecy but reticence about too much sort of publicity about exactly how they work. But yet they're brilliant people with lively minds, and they're not that many people they can talk to about their cases, so you would expect that they might be talking to each other.
And one of the things I'm sort of sensing from what you're saying is that there is a sort of, there aren't a lot of rules for judges in our High Court, that it was left more sort of fluid than perhaps, say, the United States, and which appeals to me. I like discretion and room for movement, you know, when it... Is that am I...
In the judgment writing process, it's largely a matter of practice rather than law. I think that's right, exactly. For example, there's no requirement around whether they write their own judgment or they join someone else's. That's absolutely
and no formal voting either.
And no formal voting. There are an incredibly strong set of ethics that they have about the way that they talk about it with outside of the court, so they're very careful not to talk to the parties, to other people.
Yeah, I mean, this one, I guess all the constitutional ones that make it there are big, but this one, apart from the fate of the government and these individual politicians and so on, it will be a judgment on the sort of state of our nation, in a sense, won't it?
I think
In
that's an
terms of
interesting question.
citizenship.
Do they feel a level of pressure to interpret the original, the document in terms of today's economic, social, political realities, or do you think they feel that, or not necessarily?
So the court in the 1990s, which you would remember well, under the Chief Justiceship of Sir Anthony Mason, I think consisted of judges who were more prepared to say at that time that their view of the way the community's values had changed affected the way they judged us. I don't think that is the dominant rhetoric that you hear on the court now. But I do think their views on really fundamental principles do very much come into play. So I actually think, in a way, potentially the more significant judgment was actually the judgment on the postal survey a couple of weeks ago, because the big issue there was nothing to do with same-sex marriage, which of course is terribly important, but it was really about the extent of the Parliament's control over the executive. So the question really, as constitutional lawyers saw it, was, can the executive go and spend this money when the Parliament hasn't specifically authorised it? In fact, it's specifically declined to do so. So it was really an important question about whether the Parliament is really in control or whether the executive is really in control. And so, people often think, the judge's own political views in play here. Well, not their views on same-sex marriage, but yes, their views on the relationship between institutions. And I think upholding the right of the executive in that circumstance is actually quite significant. I mean, for my part, I probably would have preferred to see more parliamentary supervision of the executive, so that there's no doubt that you can have a plebiscite or a postal survey, but you can't do it unless you get parliamentary support.
Yeah, look, I thought that those who moved that case to the High Court, it was little better than a stunt in many respects, because part of the argument that came from somebody like Wilkie was that it was inappropriate to draw that money unless it was a genuine emergency and so on. And I had two thoughts about that. One, he got caught out because he'd actually used that as a way of funding an art gallery in his electorate, which didn't help him very much in terms of the authenticity of the argument. And I think that was a significant constraint. But to me, even if the government had to go back and put in an additional appropriation bill for that money, it would have gone through the Parliament without question, because everyone's committed to not blocking supply. It would be seen as a supply appropriation bill. So, I was just hesitant. I wasn't surprised that the court just said, look, of course that can go ahead. I take your point, though, Adrienne, about the link between the Parliament and the government. And, in a way you could say, why didn't the government do that? Why didn't the government put in an additional appropriation and argue it through the Parliament, given that it would have gone through anyway? Yeah. And I think that's a reasonable question. So
whatever we think about how that case should have come out, I think it illustrative of an important thing about judging, and particularly judging in constitutional cases. So I'm often asked, is it political? Well, it's clearly, in my view, just not party political. And you'll notice what's really been, I find, very reassuring about all the public discussion we've had about Section 44 is there's been no speculation at all about whether the judges have party political allegiances that might affect the outcome, contrary to what would inevitably have been the discussion under the Supreme Court of the United States. So it's not political in that sense. But of course, judging is political in the sense that judges have views about what our institutions, our political institutions, should look like, and that those views affect the way that they read the Constitution, and they should so do.
I think you can think of another issue in my time, going back to the Fraser government and the tax avoidance days, tax minimisation days, where it was interpretations of the High Court.
That doesn't happen now?
No, but it was interpretations of the High Court at the time that led to a lot of that activity.
Right.
And over time, of course, the judgments were changed as the government actually changed its response to the challenge. But yeah, that was an example of downside, and I think Sir Anthony Mason was fundamental in turning that around from the days of his predecessors.
Absolutely.
I'd like a political view from you, John, and from Adrienne, a legal view on whether, because there's such a confidence about Malcolm Turnbull's and Barnaby Joyce's decision for Barnaby Joyce to stay in his role as Deputy Prime Minister, particularly and when he represents Australia as Prime Minister, whether that is an appropriate thing to do while such a matter is before a court. Perhaps you can go first.
Well, it's the inconsistency that's the problem. I mean, Canavan stood down and it was accepted that he should stand down because he had the question over his dual citizenship, and yet when it came to Joyce and I don't know. Anyway, of the two of them, they didn't stand down. And it was that inconsistency which was the real political issue, I think. And I don't think it would have really been of relevance to the government's numbers, but I think it raised a lot of doubt about it. And in a sense, if you listen to the way Turnbull handled it in the Parliament, he totally prejudged the High Court. The High Court will find, or shall find, whatever the words were, really hard line. Interpretation, and I think some people were drawing the conclusion from that is he trying to influence the High Court? And they're very important questions. If you want to get the High Court to perform the function that it should be performing, then don't play that game and don't bring it into the day-to-day politics of the Parliament.
How stupid was that?
I thought it was a very unwise move. I mean, I think, fortunately, our institutions are robust enough that in our system we can have a Prime Minister say something like that. The High Court shall so find, and we think, yeah, well, just you try to make them. We're confident the High Court can resist it, but we want to be careful of that culture. And, it wasn't so long ago that some ministers in his government were in, very hot water for having made extremely unwise statements about a matter that was actually under consideration by the Court of Appeal in this state. So,
and the question of Barnaby Joyce. So if, hypothetically, the court finds that he can't be in the Parliament, where legally, is there a sense or is there talk among the lawyerly set of where, particularly in the time since he knew and could have stood down, any decisions that are made that he is part of, what that means?
Okay, so the first thing to know is that the court has said that this is never, if you're not a minister, right, if you're just a member of Parliament, that your votes won't be invalidated. So there's no question, for example, if members of the government are found to not have been eligible,
they won't have to pay back their salary.
They won't have to pay. So the salary thing is dealt with in a way that they're kind of just forgiven, but actually just legally, if their votes were essential to passing legislation, it still counts. So I'm very sympathetic to the idea that you stay in the Parliament. I know that Senators Ludlam and Waters both resigned. I don't think that was necessary. I think it is much more difficult. In fact, I'm really quite critical of the decision to remain a minister. And the reason is that ministers are constantly, as John would know, constantly making decisions in their capacity of minister that are legal. They'd be granting licences, they exercise discretions, they issue all kinds of authorities. And it's unclear whether those will remain valid if it's found that, for example, Barnaby Joyce was not eligible to be elected. Now, there are probably ways the Parliament could then go and retrospectively validate that sort of thing, but, if the Parliament if the government loses one or two members and the Parliament's hung or there's minority government, that gets very complicated. So my own view is that there were legal reasons that ministers ought to step away from their ministerial responsibilities until their status is resolved.
I think this is where Section 64 cuts in, isn't it? That you have to have been,
That's right.
You have to have been a legitimate member of the House or the Senate for 3 months, and if it goes that you go backwards and that Joyce, for example, wasn't a legitimate member of the House, yet he's been continuing as a minister, It raises very significant issues.
Yeah, so the Constitution's clear that to validly be a minister, you need to be a member of the Parliament. You can be a minister for 3 months, and then after that, if you're not a member of the Parliament, then you're not validly a minister, so that would seem to follow here. And of course, 3 months was up a long time ago.
The person who did a lot of work on trying to get this Section 44 changed was Bob Brown when he was leader of the Greens. And that was presumably on the basis of the points you made before about opening up the Parliament to a bigger pool, which I'm yet to be persuaded of. I can see the merits of it, but I also can see the merits of... I'm fixated on this idea that if you want to enter Parliament, you've got to at least be a good enough researcher to find out what countries you're aligned to, and that then perhaps there are pathways that are simpler than the ones that Sam Dastyari has drawn on. To change any of this, of course, requires a referendum. And honestly, I cannot imagine, given our history of no at referendum, the idea that you could put something to the Australian people that would make the lives of politicians simpler and ask them for a yes, unless it went with a whole list of, you know, if we had one of those referendums sort of with 100 questions and they tried to slip that one in. John, can you see that as being a question that would grip the nation and have people alter it?
Look, I think it's a pretty big challenge to actually mount a campaign to reform the Constitution. There's no doubt about that. I'm not saying that it shouldn't be done and that it couldn't be done, but it would take an enormous effort because the no case is so easy to run on a referendum. That is, if you don't understand it, don't vote for it. And there are variations of that argument that you hear in the same-sex marriage debate today, or when they had to vote on whether they could recycle sewage in Toowoomba. You know, if you don't want to drink shit, don't vote for it. So it's the same argument that each time, and it's very easy to win the no case. But if you were to do it properly, and you had genuine bipartisan support, and they did campaign for the change. There's a lot of ifs.
That sounds just like same-sex marriage so far, doesn't it?
There's a lot of ifs in that because it's not easy to deliver that sort of unity on the current issue, which I think is very important, is giving a proper recognition to the first Australians. You know, that is grinding slowly to a halt because divisions are emerging within the Indigenous community and more broadly in the political system. And I think that's a tragedy. I think that should have been one of those ones like the 67 referendum where just an overwhelming majority of people across the country and in the states actually are prepared to vote for it. But it's not as easy as you would think, and they've spent a couple of years already on a reconciliation process that would deliver that outcome. And yet we are not that much closer to it than, you know, we thought we might have been a couple of years ago, and that really worries me because there's an issue that is of overriding significance to the nation that is just being left to drift to some extent, even though you've got notionally bipartisan support for that. It's still not an easy one to run, and it's not a foregone conclusion that it would get through. So in those circumstances, yeah, I think a lot of people say that one of the strengths of the Constitution is that our founding fathers made sure it was very difficult to change. But having said that, in some cases you might think it's gone too far. It's too difficult to change.
Well, this is the dilemma of constitutionalism, and the whole point is to constitute ourselves and take some things off the table so we don't revisit them all the time, and then sometimes it turns out we want to. Constitutional change takes political leadership. And it can be done. I mean, it was only in the 1970s that when Malcolm Fraser was Prime Minister, as I'm sure you remember well, the Constitution was amended 3 times. You know, it's within our memories that we've had good leadership on constitutional reform. And so I think that we ought not, I don't tout anything you just said about the political difficulties. I just think if we are fatalistic about constitutional reform, of course it will never happen. It just takes leadership, and we ought to be expecting some good leadership on this. Now, I think in the queue of constitutional reform, that Indigenous recognition is way ahead. Not actually quite as pessimistic about that, given I think the remarkable progress that was made and produced the Uluru Statement from the Heart, which I think was an extraordinary piece of progress in that debate. But I would have thought Section 44, if there's genuine bipartisan support, is a case, there is a real case for reforming it. And you wouldn't want to just reform the dual citizenship part, actually.
This was going to be my next question, actually, to you, is what is in your queue? And, like, do you just sit at home...
my queue!
Do you sit at home every night just rewriting the whole Constitution?
No, not quite, but there are some things. Look, there are lots of things in the queue. I would really like to get the racist bits out of the Constitution. I'd like to... There's a Section 25 that it's doesn't actually do anything now, but it does seem to contemplate that the states might exclude people from the franchise on racial grounds. It just shouldn't be in a 21st century constitution. I think it's important to amend Section 5126 of the Constitution, which contemplates Commonwealth discrimination on racial grounds. But my number one would be Indigenous recognition in the form that has produced the greatest level of consensus among Indigenous peoples, and that would be for what they call the voice to the Parliament, the constitutional advisory body that was proposed in the Uluru Statement from the Heart. But I would like that. I would like to see the racist part of the Constitution amended. I think we do need to have a good rethink about federalism. I personally would like us to have a republic. There's lots to do. And the wish list starts to get very long. But Indigenous recognition would be number one, for sure.
The two complicating elements in that you've just mentioned, one of them, which is that if you extend it to eliminate the racial discrimination clauses of the Constitution as well, which I think you should do. And I think, but whether or not you can win that argument in the broader community is still an open question. And of course, one of the things that have come out of that Uluru Statement is the possibility of a treaty. And that's a very divisive element within the coalition, for example, and more broadly in the Australian community. And so it is a question of leadership. It's a question of judging how far you want to go or should go, or whether you want to do it in stages, perhaps. I'd like to think that if this dual citizenship issue is settled, for example, by the High Court, there is a determination, that they say, well, look, if you don't like it, amend the Constitution. And let me see a political leader stand up and say, look, that's what we are going to do. We're going to work together in a bipartisan fashion to actually achieve that. Because I think the realities of a multicultural Australia are very different than they were when the Constitution was initially drafted.
At many of the Fit the State events this year, we've lamented about, what it is governments even do or think they're meant to do anymore. And we've looked at, different sort of portfolio areas and so on. And then you get to an area like the Constitution, and it is fascinating. And then I go back again to, that quote I read out at the beginning. You think of, there's always a downside, isn't there? They were all blokes. But in the late 1890s, these blokes without, computers in their pockets, on trains, in town halls, they achieved federation. They achieved the building of the institutions of the High Court and other things, and wrote a constitution that even today, even with you, Adrienne, it sounds like maybe I'll add a 0 onto the list of things you suggested you'd like to do. It's not that many, is it? We were given a fairly solid and somewhat flexible grounding situation to work with. Is that reasonable?
I think that's fair. I also think we ought to recall how lucky we've been. The Australian Constitution is one of the older ones in the world, but that's largely because of domestic tranquility. We haven't had war. We haven't had, we haven't had to fight off totalitarianism and all those sorts of things. Now, the Constitution is part of the story of why we've had the sort of tranquility and continuity that we've had, but it's not the only part of the story, and I think we ought to acknowledge that we've really been very fortunate, as well as having attributing a lot of foresight to those framers back in the early part of the 20th century.
Do you know, there have been a lot of debates that have come and gone over the years, and an obvious one has been whether or not we should have a Bill of Rights. You know, and a lot of people have, it's a very divisive issue, of course, and you know, it's interesting how these issues have come and gone, and there have been quite a number of them. They've never resulted in any significant drive to change the Constitution.
If you would like to ask a question, put your hand up and somebody will put a microphone in it. There's somebody up.
Hi, I just wanted to ask Adrienne, you mentioned briefly the other changes you'd like to see to the other parts of Section 44, what those might be, what shape they might take.
So there is a provision in Section 44 that requires that if you're to nominate for Parliament, you mustn't hold an office of profit under the Crown. Not obvious even to a constitutional lawyer what constitutes an office of profit under the Crown.
That was the Bill Cleary one, wasn't it?
Bill Cleary was caught
because he was a
under that.
school teacher.
Yes. But it has been interpreted to apply, for example, to public school teachers. It probably applies to academics and to very many public servants. It may even apply more broadly than that. So the position is, for example, if you're a public school teacher and you want to run for office, you have to resign, not when you win your seat, when you nominate for it, on the chance that you'll then win it. That seems to me to be yet another thing that just cuts down the pool of people that can be parliamentarians. And that's highly undesirable. I'd like to see fewer lawyers and more school teachers in Parliament, actually, myself.
That's exactly what I did. I was a tenured professor at New South Wales University, and I resigned at the time of nominating, hoping that I would win. And that is a real constraint, because it's very difficult to go back and win that spot, in my case, again. So I do think it is an area of Section 44 that could be thought of. And it's pretty vague, because we've had some examples in recent days where somebody owned a building where Australia Post rented some space. Was that an office of profit under the Crown?
Probably not, but, who, as you say...
It's worth running as an argument, and that's what happened.
Yeah, that one sounds way more important than citizenship to me, actually.
Really important, yeah.
This is a question for John. How long do you think this has actually been going on in Parliament? These latest lot that they've just discovered have got dual citizenship. Do you think this has been going on for a long time and just has never been discovered?
I really don't know. I suspect there's an element of that. I think a number of those that have come and gone may have been subject to the same sort of scrutiny. It wasn't raised as an issue, and perhaps that's why over the years I think the party scrutiny of individual candidates has probably weakened, because nobody's actually questioned it.
The Labor Party haven't got involved in this as yet, and it seems to be the only reason is that it just, by sheer luck, I would say, it's one thing that they're just sort of organised on. They've just got a better form.
Well, could I just also say it became a lot more complicated in the 1990s when the High Court held for the first time that the United Kingdom was a foreign nation under Section 44. Prior to that, it wasn't clear, and there certainly was a position where it would have been a time where they weren't. So, in the 60s, 70s and 80s, if you'd held British nationality along with your Australian citizenship, you may well have not fallen foul of Section 44. And so one of the reasons it's bubbled up, not the only reason it's bubbled up now, is because Section 44 is now operating differently.
Interestingly too, it was, as somebody in the media, this story comes up and you just think, oh, why couldn't I have been the journalist that thought of that and pick myself up a Walkley Award and, it wasn't a journalist at all. it was a barrister in Perth who, on his own time, for some weird reason, decided to look into the citizenship of Scott Ludlam. And that's how all of this started, I think. And, you know...
It's interesting that he stood down and then Walters stood down, resigned from the Parliament.
I bet they wish
may not
didn't.
have had to do that.
Well, they wouldn't have had to so far on the evidence.
The reaction of different players in this has been very different. But the High Court will have to, imagine, look at these obviously case by case and then make determinations.
Having said that, if either Senator Waters or Senator Ludlam were found in fact to be eligible, very unlikely I think, particularly given the facts with Senator Ludlam, however, if they were, then they could be reappointed by the Greens just back into the role, because the vacancy would be treated as having been triggered by a resignation. And that would create a casual vacancy and they could be reappointed. So, in a sense, there's a kind of catch-all there for them.
I'm sort of interested in what seems to be the current depoliticisation of appointments to the High Court. You know, personally, I could probably name all the members of the Supreme Court in the US and no members of the High Court in Australia.
Yeah.
So I'm interested, is that an entrenched new process? Could it be repoliticised, or has something happened to deliver what we seem to have now?
Good question.
So I don't think I've ever thought that the appointments process in this country has been political in the way that the appointments, say, to the United States Supreme Court are, not least because we don't have anything that approximates the confirmation process that occurs in the US Senate. I think there have been points at which governments have felt more and less invested in High Court appointments. And so it was very clear in the late 1990s, for example, that the Howard government was very concerned about the way in which the High Court might go in certain native title cases and made appointments with an eye to that. So I think politicisation kind of comes and goes in the High Court and in the political process. I think under the last several Attorney Generals on both sides, you're right though, that it hasn't been an especially party political process. I don't know, but I'd be willing to bet my bottom dollar that they'd do everything to find out, however, whether that they're centrists over states' rights people. That would be my guess. That'd be very important to them.
I think the expectation in the United States is that the President will try and stack the High Court and the Supreme Court. And that's not the case in Australia, although there have been occasions where there has been a tendency to try and move the High Court in a particular direction. And I think perhaps you could say broadly that it's more conservative today than it was in the early 90s.
Yeah.
And the example you used of Howard in the late 90s, I think, is a good example of where there was a concern about where it might go on some of these issues. But that's more about the issue.
Yes. Can I just say one more thing? Since a gentleman said he couldn't name any of the justices of the High Court, I just want to say everybody should know the name of Chief Justice Susan Kiefel. She is the first woman to be the Chief Justice of the High Court, and it's something of which I think we ought to be very proud.
And she was appointed by...
She was appointed to the Chief Justiceship just this year by this government, and then she was appointed to the High Court, I'm sure by a Conservative government, but I just have to remember.
Yeah, that's my memory too. The point I wanted to raise from the questioner, which is also about I couldn't name them either, but I could name quite a few of them. Go on, name them.
Oh, now you're asking me. Okay.
Let's hear it.
So, the Chief Justice Kiefel, and the next most senior judge is Justice Virginia Bell, and then Justice Michelle Gordon.
There's a lot of girls,
reigns
aren't
out
there?
the three women on the court. Justice Geoffrey Nettle is the second Victorian on the court, and then there's two Queenslanders, Justice Patrick Keane and Justice James Edelman, who was a High Court associate a few years after me and is both absurdly brilliant and absurdly young.
A round of applause.
There you go.
Very good.
They deserve a shout out,
Yeah.
I thought, for all the hard work they're doing, no matter what we may think of their decisions. But back to that point about not knowing their names, it also says something about a sort of removal, doesn't it? That they are just quietly doing their incredibly important work.
So
And that's good.
I think that's something to be very pleased about. I mean, I was like most other people that I associate with, just completely appalled by the last presidential election in the United States. And one of the questions a constitutional lawyer I'm asking myself is, can those constitutional institutions hold now in the face of, a somewhat lawless presidency or a rule of law disrespecting president? And you end up reflecting on your own system. And one thing I would say about our High Court is it's kept its powder dry, right? It hasn't unnecessarily inserted itself into political controversy. If we were to require the court to really step in and use its institutional authority, I think it's relatively well paced, partly because it has had a somewhat more muted political role over the years. Now that's been frustrating to me at times because I'm a person that would like to see more progressive constitutional solutions. But actually over the last year I've been sort of reflecting on it somewhat more maturely, I think, and thinking that actually there are some things to be really grateful for in the way the court's conducted itself.
I wasn't going to ask you this, but you brought it up. So I know you're not a US expert, but as a very intelligent observer, how do you think their institutions are holding up in the face of this lunatic?
So I think they're under pressure, but I think they're holding for the moment. So if you think about what are the institutions that can hold Donald Trump back, one is the courts, and the courts, have taken him fairly seriously to task. The only decision of which I think I could remotely approve is that he appointed someone who's very conservative to the Supreme Court, but who's a real judge.
It was amazing. It's the only actual good sort of safe, sound decision he's made, and it was the most scary one.
He's a real judge. He's a really independent person, with his own extremely conservative views. But that I think, is something to be grateful for, that, he didn't appoint Judge Judy. But so I think the courts so far are holding, but then we need to recall that he's got 4 years to make appointments to the federal court system. I think the states are resisting him a bit, so federalism is working a bit. There are states saying we're just not going to comply with some of your requirements. And so for the moment, I think you've got independent prosecutors. There are lots of institutions doing their job. But the real question will come is if he remains politically popular and if he's re-elected, then he'll have the chance to transform those institutions. So they can hold out for a while, but not forever.
I think the checks and balances have worked reasonably well, though, in terms of domestic policy, because he can't take the Congress for granted. He can't take the states for granted, or cities. I mean, on climate, for example, when he said he's backed off a bit now, but he wasn't going to ratify the Paris Agreement. Most states, key states, a lot of major cities, and of course business community and so on said, well, we're just going to proceed with emissions reduction strategies and policies. And so in a sense, those checks and balances work pretty well, I think, in domestic policy. Whether they can sustain it is a very, very important question, whether you'll get a second term.
Yeah.
But in terms of international policy, defence policy, foreign policy, there are virtually no checks and balances, and that's where we're most exposed.
I 100% agree with that last comment. That's the really most frightening part.
Just out of interest, we've got Gareth Evans coming in 2 weeks for Fifth Estate because he's written a memoir, but I'm obviously going to spend a good part of that memoir talking to him about Donald Trump and his views on it as a former foreign minister. Another question? Anyone?
You mentioned briefly the 3 Victorian ministers who were hauled before the Supreme Court earlier this year, and Malcolm Turnbull's comment to the Parliament about what the High Court will do. Generally, though, my view would be that the commentary around our courts is incredibly respectful, really. Sometimes maybe too far so. Do you agree that generally we're pretty good, or whether there's a move somewhere else, or whether it's a bad thing?
I think that courts ought to be exposed to robust forms of criticism because they're involved in governing us. And if we are to properly self-govern, we need to criticise them. And it's something that we all need to do as citizens and we need to do as scholars. And I generally think that the tone of debate around the Australian courts is perfectly acceptable. Not always, and that one big exception is often around criminal sentencing, right? But there is a big difference between criticising a court for a decision and saying something that could be taken to be an attempt to influence a court in between the time when it's, say, heard or while it's making its decision and delivering its judgment.
Like something like, for instance, saying, I know that court will see it my way.
Yeah, or that court's a bunch of crazy lunatics, and if they find this way, then we'll all know they're lunatics, for example. So and that's really what was at issue.
To paraphrase Malcolm Turnbull.
Well, actually, I think I was paraphrasing the Victorian ministers who were calling, the Victorian Court of Appeal hard lefties or something like that. Yeah, something. And I just think that the issue there wasn't criticising the court. The issue there was ministers of the Crown making comments like that while a matter was under consideration. And I think that is a more worrisome trend.
Look, I agree 100% with that. And I think they soon understood that that's how that was interpreted.
Yeah.
And they backed off and apologised as fast as perhaps not as fast as they should have, but fast enough.
It seemed very elegantly done by the court, didn't it? It was like a sort of how to parent, lesson. It was very, very smooth.
How old are your children?
2.5. 2.5. Both of them at once, yes. We are out of time already, but it's been a fascinating conversation and I have learned so much, and I'm very, very grateful to both of you for coming down, Adrienne Stone and John Hewson. Particularly, John, you flew down specially for tonight, and we're really appreciative. Please give them a big thank you.
Visit wheelercentre.com for the best in books, writing and ideas from Melbourne, Australia and the world.